Ketsiawah V The State, 1965, Ghana Law Report 483. The appellant was convicted of the murder of his former wife. On the day of the crime, the two of them had left their village together to go to a farm. A search party later discovered the dead body of the deceased in the bush covered with palm leaves. Later, the accused was arrested and he made a statement to the police that on the day of the crime he had drunk a bottle of apetition unknown to his former wife. He further stated that he appealed to his former wife for reconciliation, but that his former wife replied with abuses. Stung by these abuses and being totally drunk, he cut her with the cutlass he was holding. The medical evidence on the deceased's injuries shows that they were numerous, ghastly, and barbarous. As the trial, the closing sentence of the judge's summing up note said, he believes that the accused was so drunk that he did not know what he was doing, or that he was highly provoked, then say he is guilty of manslaughter. If you are not sure, or if you think his explanation might reasonably be true, then return a verdict of guilty of manslaughter. The court held, dismissing the appeal, that on the evidence, the plea of provocation was not available to the accused, since mere abuse could not amount to provocation in law. Again, for the defense of intoxication to succeed, it must in the first place be proved that the person pleading it was so intoxicated at the time he did the act complained of that either he did not know that the act he was doing was wrong, or he did not know what he was doing. Where the intoxication is self-induced, the person pleading it has the onus of proving that the intoxication had made him insane temporarily or otherwise at the time of the act. The standard of proof applicable to this onus was one of reasonable probability, and this standard was not discharged by bare evidence of the consumption of liquor. On the evidence, the accused had not discharged this onus. The trial judge's direction to the jury that if they believed the accused was so drunk that he did not know what he was doing, then they should return a verdict of guilty of manslaughter was a misdirection, since it did not explain to the jury that if they formed the opinion that the accused did not know what he was doing, then in law he was insane, and they should return the special verdict of guilty but insane, as provided in Section 28(3) of the Criminal Code 1960. But this misdirection had not occasioned a miscarriage of justice, since by returning the verdict of guilty of murder, the jury showed that they did not believe that the accused was intoxicated to the extent that he did not know the nature of his act.